Hi there. Welcome to the Kessler Law Firm podcast. I'm Michael Kessler, and I've been a criminal defense lawyer here on Florida's Treasure Coast for over 35 years. As you may or may not know, every state has its own set of rules or procedures for how mechanically a case goes through the criminal court system. Today, I'm going to give you a look under the hood of Florida's system. We'll start with the point of arrest and go all the way through trial. So a person who's arrested in Florida for any criminal offense is taken directly to jail, just like it says in Monopoly. Do not pass go, do not collect $200. At the jail, some sheriff's department employee will be responsible for the booking procedure, which includes getting your name, getting your birthday, taking your picture, taking your fingerprints, and entering all of that into the computer so that now that there's a record of you. They'll add to that the agency case number, which is a number designated by the law enforcement agency that made the arrest. At this point, the booking officer will take a look and see if there's a standard bond schedule in place in the county in which you were arrested. If so, they will set the standard amount of bond, which is your temporary bond. I say temporary because you have from that moment until the first appearance bond hearing, which I'll explain in a minute, to post bond and be released pending further proceedings. In Florida, everyone who gets arrested and does not bond out is entitled to have what we call a first appearance bond hearing. That is, they appear in front of a judge or magistrate. The judge or magistrate's job is to review the arrest report, make a preliminary non-adversarial finding whether the facts alleged in the arrest report are sufficient to establish probable cause to believe that a crime was committed and that you're the one who committed it. If the judge finds no probable cause, the judge may release you without having to post a bond. We call that a release on your own recognizance, or ROR. If the prosecutor at your first appearance bond hearing asks the judge has the discretion to hold you for 24 hours, give the state 24 hours to supplement the police report with additional information, and the judge can review your bond situation the following morning. If there's a bond already in place from the bond schedule, you don't have to wait. You can go ahead and post bond. But if you're hoping for an ROR release, you may sit another day. In Florida, a person can be held without bond, but only for certain crimes. A person can be held without bond for any crime punishable by life or death. A person may also be held without bond on a violation of probation, but that's because violation of probation, strictly speaking, isn't a crime at all. It's merely a violation of a judge's prior sentencing order. So different rules apply there. And one of those rules is no automatic entitlement to bond. Now, a person who can't bond out because of the conditions, monetary or otherwise, that the magistrate or judge sets at first appearance, can take basically a second bite at the apple. The judge or magistrate holding the first appearance hearing is done with you and your case at the end of that first appearance hearing. Your case then gets assigned to a trial court judge. Theoretically, it could be the same judge, but it doesn't have to be. In any event, once your case gets assigned to the trial court judge, you and your lawyer can file a motion asking that judge to review your conditions of bond and adjust them, lower your bond, remove or adjust certain conditions. Once you have either bonded out or realized you're not going to bond out, the clerk's office places your case on a virtual conveyor belt. Unlike civil court, where cases don't move at all unless one side or the other takes action to move them, In criminal court, the clerk's office pushes the cases along. Your first court appearance after a first appearance bond hearing is what we call arraignment. Arraignment is an old-fashioned proceeding. The purpose of arraignment is for the trial judge to make certain that you understand exactly what it is you've been accused of by the government of the state of Florida. So if you go to court for your arraignment, when the judge calls your name, you will walk up to the lectern, or these days you might be appearing on Zoom or some other video conference. But the judge calls your name, identifies you, and then explains to you what you're charged with. For example, the judge might say, Mr. Jones, you are charged with the crime of DUI, driving while impaired. Do you understand the charge? If you say no, the judge will take out the statute book and read you the legal definition of DUI in Florida and ask again, do you understand what you're accused of? If you say no a second time, the judge will probably read the statute again, perhaps slower and more loudly. Eventually, you're going to say, yes, you understand. The judge will then ask you, do you want to be represented by a lawyer? You have a right to hire any lawyer you want. You have a right, if you cannot afford a lawyer, to apply for the services of the public defender. That would require you to fill out a financial affidavit, and a clerk of court will decide which side of the line, indigent or not indigent, do you fall on. You also have the right to represent yourself. At an arraignment, a judge probably will give you a basic warning on the dangers of representing yourself, but probably won't push it at this stage. After clearing up whether you want a lawyer or not, the judge will ask you, in response to the charge or charges, how do you plead? A person can plead guilty, which says, I admit that I committed this crime and I have no defense or justification. Or a person could plead not guilty, which says either I didn't do this crime, or if I did, I have a legal defense or justification. An example of that might be self-defense or legal insanity. You might have heard the term stand your ground. We're going to talk about that in another podcast, but stand your ground is basically a subset of the traditional self-defense. So a person can plead guilty or not guilty. A person also could plead no contest. No contest, strictly speaking, says, I'm not admitting or denying this accusation. I am simply choosing not to challenge it or contest it. That should feel very much like pleading guilty, because it's almost exactly like pleading guilty. In fact, it's pleading guilty without saying the word guilty. In other words, a judge will treat a no contest plea exactly the same as the judge would treat a guilty plea. And the judge would then proceed either immediately or at a later date to conduct a sentencing hearing. At a sentencing hearing, of course, the judge would be deciding exactly what punishment will the judge impose on you as a result of your guilty or no contest plea. At a sentencing hearing, the judge is free to impose any legal sentence, anything from the minimum that the legislature has established as mandatory up to the maximum which the legislature has established as the cap or ceiling. In the event that a person pleads not guilty, their case then goes back on this theoretical conveyor belt pushed by the clerk toward the possible eventual trial. There may be a number of stops on the way to trial. I find that since I take cases all over Florida, different courts use a different term to describe this. Some call it a docket call. The docket is the word we use to refer to the court calendar. Some call it a calendar call. Some merely call it a pretrial hearing or a case management hearing. In any event, when the case arrives at this hearing, the judge typically will ask both sides, the state and the defense, is this case ready for trial? If it's ready for trial, the judge will set a date for jury selection. If the case is not yet ready for trial because one side or the other has more work to do to get ready, then the judge will grant what some people call a continuance. In some places in Florida, it's called a postponement. In some places, it's called a reset. Whatever it's called, it means that the case goes back onto this theoretical conveyor belt and get pushed down the road to the next cycle. The judge at this case management conference, we'll call it, can also set a hearing date if the sides have reached agreement on a plea instead of a trial. Sometimes the judge will have time to take a plea agreement right there at the case management or docket call. But oftentimes, for the convenience of everybody else, it's set for a separate date. Now you're envisioning your case traveling on this conveyor belt. And once every cycle, which in my experience is typically every 4 to 5 weeks, the conveyor belt turns into more of a rotisserie or a Ferris wheel. That's for the case management conference or docket call or whatever we're going to call it. At that stage, at that hearing, a judge actually checks one by one on the status of every single case in that judge's open inventory. So cases get reviewed on a regular basis. And that's intended so that cases don't fall through the cracks, so that judges can push both sides to do their jobs and get this case ready so it can be resolved. And it's also, in many instances, an opportunity for the judge to verify that the person is complying with bond conditions and hasn't fled the jurisdiction. Now, generally speaking, if you are the defendant in a pending criminal case, you're required to attend all of these hearings, but there are exceptions. For example, going back to the arraignment, the people that wrote the rules of Florida criminal procedure, they expect if you have a lawyer, your lawyer can explain to you what exactly you're charged with, and you don't really need the judge to do that. For that reason, you don't have to appear in person for arraignment. If you have a lawyer, your lawyer can appear in your place. In fact, your lawyer can waive the arraignment altogether by simply filing a document called a written plea of not guilty and a waiver of arraignment. When I was a very young lawyer, when every hair on my head was jet black and I couldn't grow a mustache, let alone a beard, arraignment was actually an opportunity to resolve some cases early on. Prosecutors would bring the files to court and had already become pretty familiar with the background of the case and the background of the accused person. But because of the growth in workloads over the last 35 plus years, arraignment doesn't serve that purpose very much anymore. Oftentimes, a prosecutor's office will send one or two of its lawyers over as more or less officers of the day. The files may or may not accompany them, but even if they do, prosecutors don't seem to be anywhere near as familiar with their cases at this stage as they were in the good old days. For that reason, I almost never go to arraignment in person anymore. On my cases, I will almost always file a written plea in advance so that my client doesn't have to take off work to go to court and so that I don't have to waste time going to court for no real purpose. Likewise, at most pre-trial case management hearings or docket calls, these status conferences, you're required to be there, you're entitled to be there, but you don't have to be there if you sign in writing a waiver of your right to appear. On my cases, for my clients, unless there's a really good reason for them to be in court for this status hearing, I would accommodate them by letting them sign a waiver of appearance that we prepare, and we'll file that. Most of my clients would prefer to not take the day off work and go on to work or go on to sleep or go on to go fishing, and they probably have something better to do than just a status conference if the likely outcome is that the case gets postponed and no other significant development. Let's talk about timing so you can know what to expect. As I've said, I take cases all over Florida, and I find this to be true just about every place. Prior to COVID, a reasonable period of time for a misdemeanor case to go through the system from arrest to ultimate resolution, whether that was dismissal, plea agreement, or trial, typically was 3 to 6 months. I find it's about twice that now because of the interruption of the norm caused by the coronavirus. Prior to COVID, felony cases, in my experience, for the most part, would stay open 6 to 9 months. Obviously, there were exceptions. Certainly, there are lots of things that a lawyer can do that result in a case taking sometimes quite a bit longer. There also, of course, are moves that in normal times a lawyer can make to make a case get to the finish line much faster. In another podcast, we'll talk about Florida's speedy trial rules. I'm not going to bother with that today because about a year ago, the Florida Supreme Court suspended Florida's speedy trial rules for the duration of the COVID pandemic. So there aren't a whole lot of things these days that your lawyer can do to get your case to the finish line faster. I'll also tell you what I always tell my clients. We want to get you the best possible result, not necessarily the fastest possible result. You might have suspected from what I've told you so far that getting a case to trial can be a challenge. And you're right. There are a number of steps along the way that slow things down. Once I'm at a docket call and my case is ready for trial, the judge calls my case, I will say, ready for trial, hoping at that point that the judge is going to give me a trial date in the following week or two. Sometimes that doesn't happen. Sometimes the prosecutor's not ready for one reason or another, and the judge would grant their request for a postponement. If that happens, back on the conveyor belt we go. Sometimes, because of the number of cases that announce ready at a docket call, a judge will have a preliminary additional step around the Treasure Coast they call a mini docket call. And that's basically a weeding out process so we can appear a day or two before the actual trial would be and tell the judge, are we really, really ready? At that point, the judge would also want to know from any of the lawyers, are there any witness scheduling problems, any lawyer scheduling problems? Because judges want to have enough jurors to try the cases that are set, but they don't want to inconvenience jurors unnecessarily. So a judge doesn't want to have a couple of hundred people come in for jury duty, especially these days, if there really aren't enough cases that are actually going to go to trial. So I can announce ready for trial at a docket call and then come to a mini docket call. And typically the judge will have a mini docket call to cover what's going to go to trial the following week. And so the judge will try to identify, for the judge's sake as well as for the lawyers and their clients, what's the order of cases for trial next week? Who is likely to be first, second, third in line, and so forth? Now, most judges I know will still set more cases than they can get to, but that's because we recognize that sometimes when lawyers and their clients take a good hard look at a case a day or two before court, their opinion of what's likely to happen may change, and cases sometimes get resolved through settlement or dismissal. And again, the judge doesn't want to have a whole bunch of jurors in the jury room on a Monday morning and have all the cases go away. That happens, and it happens often, but that's not what any of us want. So here in general terms, we've taken your case from the point of arrest through the mini docket. Let's say we now show up for jury selection. We're first in line. We're first in line when the judge goes through the cases on whatever morning we're picking our jury, the judge will at some point bring a bunch of jurors into the courtroom. The jurors will be sitting in numbered seats, or at least they'll be assigned seats, and they'll be sitting one through the end. Let's say there's 30 for a particular relatively straightforward misdemeanor case. So we've got 30 potential jurors. We call the process we're going to go through jury selection, but it's really jury elimination. Jurors are sitting in their numbered seats. The first 6 people who are not excused are going to be your jury. Oftentimes we'll pick the next person who's not excused to be the alternate. The alternate sits with the jury through the trial, but if none of the first 6 gets sick or dies or otherwise kicked off the jury, the alternate is thanked and excused, and they do not participate in deliberations. So jury selection, the most common method that I see is that a judge will initially interview the panel. For some judges, that means talking to the group of jurors as a whole. For other judges, it means one by one talking to every single juror. We also are typically given, in addition to our seating chart, of course, a very, very superficial questionnaire. Typically, it's 1 page, and it may suggest certain things we might want to talk to individual jurors about, but it doesn't tell us very much. After the judge has finished talking to the jurors, the prosecutor goes next. The prosecutor will always go before the defense attorney. That's because the burden of proof is on the prosecutor, and they're going to go first in every stage of the trial. So the prosecutor will speak with the jurors first. It's not unusual for prosecutors to feel that they must say something to every single juror in the panel. Once the prosecutor has completed their conversation with the jury panel and with any individual jurors, then it's the defense attorney's turn. Defense attorney has the option, if he or she wants, to speak to every single juror as well. When the defense attorney is finished, typically the jury is excused from the courtroom. They are kept out in the hall with a court security officer or bailiff keeping an eye on things. And the lawyers and the judge then discuss whether any juror or jurors ought to be excused. There are 2 kinds of excusals in Florida. There is what we call a cause challenge, and there is what we call a peremptory challenge. A cause challenge, as the name suggests, is a juror can be excused for cause. In other words, if there's a reason. If there's a reason why, as a matter of law, this juror can't sit on this case. It could be because of who the juror is. If the juror is the spouse of one of the lawyers or the defendant, well, that's grounds for them to be excused. I actually had that happen in one of my cases. I was set to pick a jury in federal court, and my wife was in the jury pool. And I actually went to court early that morning to let the judge know. But I also asked for a favor. I said, Judge, I give you my word as a gentleman, in addition to my word as an officer of the court, I will not let my wife get anywhere near actually serving on this case. But could we just be patient and see how long it will take for the prosecutor to figure out that that's my wife? The judge agreed. And as we went through jury selection, the prosecutor was almost finished with his questions. And he finally said, is there anybody on the jury panel this morning who thinks they might already know something about this case? At this point, my wife raised her hand. He called on her, and he called her Mrs. Kessler because that was her name in the seating chart. And her answer was, well, my husband is the defense attorney, and so I know quite a bit about this case. The judge lifted up his court file to hide his laughter from the jury and granted the prosecutor's request to excuse my wife from the panel. That's an obvious example of cause. Sometimes jurors say something that requires them to be excused for cause. The something could be fairly innocuous. I don't speak English well enough, or I don't hear well enough, or I have some other physical ailment that would interfere with me sitting for a lengthy period of time. Those people can be excused for cause. Sometimes it's because something people say tells us that they can't be counted on to be fair in this case. For example, if a juror says, I couldn't find somebody not guilty unless they testified and convinced me they were not guilty. Well, that juror can't serve because they've indicated they're not going to follow the law. In a criminal case, the accused person is presumed to be innocent and doesn't have to prove his or her innocence. The burden of proving the accusation is on the prosecution, and it stays there throughout the entire trial. So anybody who says, well, unless the defendant testifies and I believe him, I couldn't find him not guilty, they're not following the law, they can't serve. Part of the presumption of innocence, in fact, means that the accused doesn't ever have to testify. And a jury would have to be instructed that if the accused person doesn't testify, the jury can't consider as any evidence of anything. Sometimes jurors give us information about their life, their relationships, their experiences that make it inappropriate as a matter of law for them to sit on a particular case. For example, if a person is accused of a sex crime, or let's say a crime involving domestic violence, and a particular juror has been the victim of such a crime themselves, or a crime like that happened in their family, sometimes they tell us that they're not certain that they could be fair in that kind of a case. And they might yield to their sympathy to one side or the other. That's an example of somebody that might also be excused for cause. A potential juror cannot be excused for cause based on their race or their religion or their ethnic background. Sometimes there's a juror that I don't want on a jury, but I don't want to give a reason. The law provides us with what we call peremptory challenges. Peremptory challenge is just a challenge for which I don't have to give a reason. In a misdemeanor case in Florida, lawyers have, or parties have, 3 peremptory challenges. In a felony case, they have 6. In a capital case, they have 10. And again, like cause challenges, peremptory challenges cannot be excused based on a potential juror's religion or race or gender or national origin, things of that nature. In any event, because the jurors are sitting in numbered seats, or we know their order, we also know if a juror is excused, who's next in line. So a lawyer or a client can make tactical decisions on, all right, I don't like juror number 6, but I really, really don't like juror number 7. So I'll keep 6 and keep 7 off the jury. The accused person is certainly entitled during this period to talk to his or her lawyer and have input on who should be kept and who should be excused. I always want to hear from my clients on their wishes, because even though I'm the experienced trial lawyer, it's their case. It's your case. It's not my case. So I want to hear what you have to say about the people who are going to sit in judgment on the state's case against you. So once we have our 6 people and an alternate if the judge wants it, the rest of the jurors are excused. They can go about their business, including sitting and watching the trial if they'd like. The people who are chosen to sit on the jury are then sworn in. They have to take the juror's oath. And then, according to the judge's schedule, the trial will begin. It's not unusual, at least in this part of Florida, for the trial to begin the following morning after the jury is picked and sworn. But that can vary from place to place and based on the judge's needs. I've certainly tried lots of cases in my career where we picked the jury and we did what we call pick and go. Now you know how a case goes through the system up through the beginning of your trial. We're going to talk about how a trial goes in another podcast. Thanks for joining us for today's podcast. I appreciate your spending a little time with me. If you'd like to know more about the Kessler Law Firm, you can find us at www.kesslerlawfirm.com. If you're watching this on YouTube, please click the subscribe button so you'll know when new episodes of our podcast are available.